And today I'll be discussing to you with two another important topic. One is the procedure in respect of land acquisition and the social impact assessment under section 4. In fact, section 4 to 9 speaks with this. First, very briefly, my friends, let me discuss to you with the procedure in respect of the land acquisition to be followed by the authorities. What are the procedures they go in proceeding with the land acquisition? Friends, when it comes to the land procedure, acquisition procedure, we have understood this, the right to fair compensation, transparency of land acquisition, rehabilitation and resettlement act 2013 provides for the compensation on the expropriation of any land, house, building or any other kind of immovable property which is being referred under the act. And it also made a specification under section 3 clause 2a is that when a land is needed for the public purpose, then such land acquisition can be made, or where the land is required for PPP, land acquisition can be made, or where it is for the private company or private entity, the land acquisition can be made. So in that case, we shall see this, the land acquisition can be made for all this purpose, and of course you do also require to write this when the question is asked with. But whether if the same acquisition is made at the state level, then even the state by its own amendment, bringing a laws into it and having an amendments to that, that is satisfying to the requirement, that is to the local requirement of that area, the state shall also have a power of having, making or providing certain laws in case of land acquisition. And wherever it is possible, in addition to the parent act, the state legislation should also be equally taken into in case of land acquisition. And withstanding to this, my friends, under section 104, it also says that where if the state or central government, where if it is possible to have, or the appropriate government, when it is possible to provide that instead of having going to the acquisition, that is acquiring a land for the purpose of any of these factor, but if the land is particularly required for the minimum period or a temporary period, then it can even opt for a lease. That's what we say is that a part of you having following the state legislation, if it is of the opinion that the same could be achieved by way of you taking the lease of those land, then in such cases those land can be also be taken by way of lease by you. But that is for a temporary period. But where if the acquisition goes for a land which is permanently required with, then we shall say that that is where private land or the land is being taken away, then you have to undergo with these procedures, my friends. One is the preparation of social impact assessment, that is what we call it as SIA study, preliminary notification under section 11. This is the second thing. Each one you have to explain. Maybe in my coming videos I'll be just discussing to you, but separately on this part. But for the purpose of you to attempt for the examination, I'm just giving you all those heads and you have to explain all those heads here, my friends. Again, that is, one is preparation of the SIA study, that is you have to study and you have to make an assessment of it. Second one is preliminary notification under section 11. Under section 19, there shall be a declaration of notification. Under 14, notice shall be given to all those persons interested in respect of that acquisition. Inquiry of the award shall be made under section 23. Then the body can proceed for taking the possession of the property under section 38. Even in spite of any litigation or any dissatisfaction is shown in this, then the reference can be made to an authority under section 64 and acquisition of land can be made even to that of the company. So these are the procedures which is to be followed in the case of land acquisition. And after which the next question comes as resettlement, rehabilitation and resettlement. I would always like to inform you with this thing, my friends. Many a times our friends, student friends would confuse in writing with the two questions of this. This is one question could be with the procedure for land acquisition, and the second question could be for the procedure with respect to the rehabilitation and resettlement. These are the two questions which could be. Don't mix up these two questions together while answering. Please understand the question what is asked and then write all these things. Friends, have just given you the topics, because each topic I'll be discussing separately on my separate video discussions. So each topic what I am discussing there should be written as a procedure for the acquisition of land. And the next comes is the social impact assessment. We shall look what is social impact assessment and how social impact assessment is going to be carried with. So when it comes to the social impact assessment, ಕನ್ನಡದಲ್ಲಿ ಸಾಮಾಜಿಕ ಪರಿಣಾಮದ ಮೌಲ್ಯಮಾಪನ ಅಂತ ಕನ್ನಡದಲ್ಲಿ ಹೇಳ್ತೀವಿ ಇದನ್ನ. When we speak upon which, as I then said, it is section 4 to 9 speaks with this. See, the very concept of bringing social impact assessment in the new enactment of 2013 or introducing in the new Act 2013 is for the reason to have a orderly proceedings with respect to the land acquisition, and also it aimed at having a comprehensive participation from the central government, from the state government, and also from that of the persons who are going to lose their land. And in order to have a meaningful process and to have a transparency in respect of the land acquisition, this social impact assessment was being brought in. And of course, my friends, we see this because of the social impact assessment, it has also led down to the need of rehabilitation and resettlement of those affected families. So the consent has to be obtained. In fact, principally, if you look upon with the social impact assessment, the three major objectives behind of which the social impact assessment was being brought in. The first is that, in fact, by you going with the social impact assessment, it seeks to put in place of what you have been. Or I can say you that this is a robust framework which has been developed or which has been brought in conducting the acquisition, and it also gives out a way for comprehensive analysis by conducting a social impact assessment. And for this reason, the proposed acquisition shall be made in consent with that of the landowners. So you are equally taking the participation of those affected persons in respect of the land acquisition. That was in first principle wherein which social impact assessment was brought in. The second one is, the objective is that by this SIA, this would have an adequate safeguard to check the balances and to also ensure the free and fair way of acquisition process. That is, when you obtain a consent from that of a person, of course it made a restriction saying that such consent what you are obtaining shall not be a coercive in its nature. It should not be a coercive method wherein obtaining a consent, so that when you going for social impact assessment, obtaining the consent, there should also be a suitable safeguards which should be given for the persons to have their free and fair consent, which should be provided by those land losers. To that extent, also it said that there should be a free will of consent should be given up by the parties. And the third one is that it clearly said, in fact, the social impact assessment in its report, or after filing the report, it clearly says that any delineate, that is, if you are describing as what the property is going to be acquired with, then it shall also specify the time within which the acquisition has to be completed. You have to give out with, that is, it makes out the entire process of acquisition has to be made more expeditiously as possible. So in that notion, my friends, this social impact assessment was being made with. So we can say that is in the proceedings of the land acquisition, I can say this social impact assessment is the first stage wherein which we go for a land acquisition. It is in this social impact assessment we would come to know the extent of what the people are going to lose the land, extent of which people are going to lose their livelihood, and it would also say upon that what would be the impact of this acquisition over the both movable and immovable properties. And for this we see the social impact assessment study should always be done in partnership, as I then said, in partnership with that of the members, with that of the panchayats, with that of the local body, that is local bodies or institutions, and municipalities. And all this discussion what you are going to take should be in the local language of which the persons are aware with. And it imposed a time limitation that this social impact assessment should be completed within the period of 6 months from the day of its commencement. In fact, it gave you 6 months plus 2, so in all together it is 8 months. 6 months for your study purpose and 2 months is for the purpose of you making a report on it. The report shall also be equally prepared. So this would be the very first stage of which the acquisition proceedings takes place with. And in the second proceedings, in the second way, or at the second stage, we see that the social impact is also assessed by the experts groups. That is, once when the study is being commenced, or when the study is being made, and of course all this should be made within 6 months of time, the time frame should be fixed upon with this. When you are going to have a study of social assessment, that assessment has to be made by that of the few expert groups who are an independent in nature and are also of a multidisciplinary group. They are from the multidisciplinary group who would consider that what shall be the social impact of that acquisition and what is the extent of the utility of that land which you are going to acquire with. And this multidisciplinary committee who is going to consist with the social impact assessment would be of like this. In fact, there are 7 people or 7 persons who would form to be a committee, that is of the group. That is 2 from local self-governments and 2 from the experts community, that is more particularly who are carrying out or who have carried out the work of rehabilitation and resettlement, and 2 from the non-official social centric persons, 2 again repeat, 2 from non-social centric persons, 1 should be of a technical expert. So out of these 7, 1 would be appointed as a chairman of this committee. So with this person, my friends, they should go undertake the assessment of what they are doing. They have to apprise with, and they should look out into this and apprise the same thing in the report by giving a recommendation of such a report what they are making with. In fact, when it comes to the recommendation, there are 2 types of recommendation which you can make out with. 2 types of recommendation. The first recommendation should be on the cost benefit analysis. Why I say this cost benefit analysis is that, they have to look out, making their report stating that whether the benefit from acquisition would outweigh the development project. That is, whether the acquisition process would outweigh the development project, or whether the acquisition would outweigh the project itself. That is, which would weigh more, whether the acquisition would be good enough or whether the project would be good enough, how these 2 weights to each other. Usually the acquisition proceedings would always take place on the basis of the report wherein the development project outweighs the acquisition of which the acquisition is going to be made. So that has to be recommended by this acquisition committee. And also the second thing is that, my friends, it says that the expert groups should be of the opinion that this potential acquisition would lead down to a potential development and it is less cost when it comes to the beneficial project. It is less cost to that of a beneficial project than it may go upon for recommending, or it can reject out the acquisition proceedings which the company, that is which the government, appropriate government would look upon in that of the area. And this report, as I then said, should be filed before within 2 months of time after having constituting the existing group, that is 6 plus 2 months of time which has been made. And this report of the express group is called as SIA report, and this would be considered by the appropriate government. And then comes the procedure. The third procedure is preliminary notification. The fourth procedure is the next stage of land survey. The fifth stage is declaration of acquisition, and the fifth stage is declaration of acquisition, and the fifth stage is declaration of acquisition, and the sixth stage is compensation for R&R activities. So these are the procedures in which R&R, social impact assessment, is going to be carried. And having doing this social impact assessment, my friends, it is the bounded duty that the appropriate government has to maintain a website here. That is workflow statement that they have done. That what they have that is what the committee have undertaken with. There shall be regular or frequent site visit, that is land visit, which they are going to make. That is when they go for a regular visit, they should also adopt certain strategies such as a focused group discussion, detailed rural appraisal, informal interviews with those of the affected persons, in order to appreciate the nuances that they could involve in respect of the acquisition, or that just to overcome with those of the negative influences which the views of the landowners are taken with. So in this way they have to carry out, and what all that they have carried, what all the negotiations that they have been done with, all those should be uploaded in the website which is being maintained by the government. So there shall be a separate website to this. And furthermore, to speak with, the team is also obligated to scrutinize the relevant records, the data, and also with the field verification, and compare this field verification with the project which has already been concluded, with the existing project, or with the existing project which it is doing with. It has to carry on with all these things. And then once when the team investigation, it should also look into these credentialities. It should focus us on these credentialities. One, what would be the most adverse effect of this project? That is, whether it could be on the environment or whether it could be on the social point of view. What could be the adverse effect on these two areas should be focused on. That is mostly on these two areas. And it should also focus us on whether the quantum of land what is going to be acquired is more or less, or it is more than what is necessary or less than what is required with. It is to focus on this. The third one is that it has to also make its understanding with the feasibility of the executing the project with any other alternatives. If any other alternative is there, that has to be opted, that has to be specified. So feasibility of the executing the object should also be spoken out with. And if the land falls in any of the scheduled areas, as I was saying, under 5th and 6th schedule of the Constitution, then whether the acquiring body are able to prove that such land what they are going to acquire is a last resort of them. They should be able to demonstrate that. They should be able to demonstrate this is the last resort in the course of acquisition. And it says that as a fifth area, it says that an analysis of the acquisition has to be made, structure in which it is going to be taken out with, and also the location of the land is good enough to go with. See, when it goes with the analyzing the type of the land, structure of the land, location of the land, it is going to speak upon with, address upon with, it should give a due consideration to the case as that whether the land is an irrigated land or whether the land is put under irrigation. What is the crop pattern? What is the type of crop that the land is being grown? Must be clearly, completely analyzed with. And it should be what area that it is going to, because under section 10 we see food security is also there, my friends. So it is with that reason even a due regard has to be given to this part of the area. And as I said that when the course of acquisition is being made, the report has to be made. What would be the effect of such land, irrigated land, crop pattern, looking down to this, what would be the effect of this land on the food security in case of acquisition. This has to be clear, understood very clearly, very happily in explaining with this. And apart of this, it also speaks what is the ownership pattern, what is the size of ownership that the people are holding, what is the change of ownership for the last previous 3 years. And for to have a more transparency, it is also required, my friends, the team, while conducting interviews with that of the members, or I can say public hearing with that of the local peoples whose land is going to be taken, or in Grama Sabhas which they are going to taken, then those should have been video recorded. The acceptance, the application, all this should be made, and that should be made in the website of the government. And public notification should be issued. That is, if the officers or the officers who are going to have an interview with that of the members who are going to have an affected area, then at least 3 weeks before, a notice has to be served upon them for having a public hearing, or to the stakeholders they have to give at least 3 weeks of notice prior. Only then they can go with. And all members should be given with a copy of the draft of which they are going to have an acquisition. What is their contribution? How the acquisition goes based? What is the impact of this? That is, a details would be made out as why, what, and when. These information has to be given to it, and again I say all these proceedings must be video recorded. That is, the meetings which they have, it should be video recorded, and it should be made only in the local language. So subject to this, my friends, we shall see the social impact assessment is to be made. And this social impact assessment, as I then said to you, should be prepared within 6 months of the commencement of the assessment of process. And there they should give out the findings. In fact, the report should come out with the findings of it, the team, how it has worked, what all the key areas of investigation that they have carried earlier, and now what is that their opinion on this. It shall contain a statement to that of the number of affected families, what would be the socio-economic profile of having making acquisition in that area. They should clearly specify that how would this project would outweigh the social effect, and examine the efficiency measures in having making this acquisition, and also which the government is required to undertake with the migrants of those who have lost their land, that is those of affected families. So migration and rigorous acquisition, when it goes back, what would be the perspectives of that of the affected families shall also be made in their report. That is, the report shall say upon with these things, and the report should be submitted by the expert. The expert should also make their concern, and on the basis of this, my friends, the report shall be given to the government. And once when the report is being given to the government, the appropriate government can analyze that report along with the recommendation made by the expert panel in this area. Then they can formulate a strategy of looking down to the recommendation, and they can make a strategy to minimize the ecological impact by this social acquisition, harm that could be affected to the families, and also speak upon with the adverse consequences of this acquisition. So in all this method they have to go upon with. And in fact, we can say that there shall also be a social impact plan created. In fact, we say that when we address upon the social impact plan, my friends, the management plan has to be made. It should be entirely addressing to the 5 areas are concerned. That is, they should speak upon how can you manage the social impact. 5 areas. What are the strategies that you can follow to avoid, to mitigate that of the adverse impact of that project? They should speak upon with this. Steps for R&R affected families. R&R is then, I'll be taking R&R. R&R is that rehabilitation and resettlement of the affected families. Steps, what are the steps that you can take in this regard? Brief explanation of the body requiring the land intended to, and how far that is going to be benefited to that of the affected families. If there is any additional claims that is being made by the body, then body requiring, that is during the social impact assessment, should also be brought in. and the key personals who are responsible for casting a social impact assessment, what is the timeline that is being given to, and what is the expected cost that could incur in respect of social impact assessment. All these things has to be made. My friends, we can say that SIA serves an useful services, especially with reference to the developing and I can say that it is the most effective strategies wherein you can adopt for the reconciling the interest of the landowners from the requiring body, and I accept with this also. And at the second part of our discussion, if you can say that how can you obtain a consent from that of the people? What are the modalities you can follow in obtaining the consent of the members? See, as the Act says that it is mandatory that you should obtain the consent from the landowners. And it is very mandatory too. Again, repeat, it is very mandatory too. Especially where if it is PPP project 70, as I then said, if it is private entity, it is 80%, you have to obtain the consent. Only with the consent of those persons, you can go with. That's what we see. Of course, the regulation 2014 to some extent it excluded, but we see that what would be the effect of ordinances. So, subject to this, my friends, the consent has to be obtained. And why is this consent is to be obtained is just to have a smoother flow of acquisition. That is, with that we are looking at. That is, the appropriate government is, for this, my friends, for the smoother flow of its acquisition process, the appropriate government is required to maintain a record of the landowners, the persons who are having a land right, and also the persons who are in occupation. And while making a records, they have to give due interest to the forest laws and also revenue laws are concerned. So they have to maintain a record of it. They have to show that what is the number of landowners, how many number of landowners they have given a declaration to this effect, how this landowner is depending upon those of the land, the details of that of the officers who are taking the contract, who are entering into such consensus by that of the parties. All this should be given by them. And finally, my friends, the consent of the landowners should be recorded in writing. I wish I have said this, that they should be made a record in writing with the consent process of how they have been made. Otherwise, your consensus obtained by the landowners becomes ineffective. So in this manner, my friends, we can see that the land settlement, the SIA can be made. And in fact, SIA report should also state that what is the extent of settlement that they are going to make in. Whether you are going to make a settlement by way of employment, especially these two criteria I'm speaking. Whether they are going to make a settlement in the case of employment, or whether they are going to pay it in form of one-time payment of 5 lakhs of rupees, or whether they are going to pay 2,000 for the period of 20 years for their sustenance living. And even for this, my friends, the report should also make it to the extent of that what would be the cost of transportation of these person when they are migrating from one area to another area. So to the effect of this, my friends, there shall be a report made upon with. So a main question could be asked you with about SIA. They can ask you, right, saying that what is social impact assessment and state the procedure of conducting social impact assessment. One question, or the question could be for the short notes is social impact assessment or social impact report. These two can be asked for your examination. So this is one requirement you have to go upon with. The next part of the discussion which I would be going to is with the preliminary investigation, which is under section 4 to 9 speaks with, after having prepared the social impact assessment, how preliminary investigation is going to be made. So referring back to the social impact assessment, like speaking to you about how they look into the social impact assessment, then how the preliminary notification would be issued. This I'll be discussing to you in my next video.